Okay. Is that okay if we start right now, Prof?
I cannot. So I deliver the lecture now. Okay.
That
Okay.
you send to us, right?
Yeah, sure.
Oke. Dia kemarin yang saya kirimkan materi bukunya mungkin bisa di-share.
Mas Jalu, mungkin di-share materi yang dari Prof. Pak yang buku itu ya, tekanan Indonesia itu ya.
Baik, Bu, sebentar.
Yang tadi pagi kan Mbak Dita?
Ya, Bu, yang buku, Bu, yang
Oh, yang buku.
saya
Jalu, tolong di-share ya. Oke. Ini yang hadir dosen-dosen Mbak Dita, kemudian ada mahasiswa juga, baik S1 maupun S2.
Di sini udah ada sekitar 40 peserta, tapi kayaknya ada yang masih di waiting room, Ibu.
Mas Jalu mungkin bisa di-admit semua aja. Ini yang hadir ini dosen dan juga mahasiswa S1 dan S2, Mbak Dita.
Baik, Bu. Sebelumnya Bapak Ibu perkenalkan, nama saya Dita. Kebetulan saya ditunjuk menjadi staf ahli di Fakultas Hukum Universitas Gajah Mada, menjadi staf ahli di bidang internasionalisasi. Saat ini saya adalah dosen Fakultas Ekonomi di Universitas Wijaya Kusuma Surabaya dan juga mahasiswa doktoral di Kyungsung University Busan, Korea Selatan. Can you see it, Prof?
Yeah, okay. So can I move the screen myself?
Mohon Prof untuk diberikan remote mungkin ya, supaya bisa move.
Mas Jalu, Prof Pak sama Mbak Dita jadikan co-host ya, Mas Jalu. Halo Mas Jalu. Mas Jalu, Mbak Putri. Oh, sebentar saya jadikan co-host saja. Mbak Dita sama Prof Pak sudah jadi co-host.
Baik, Bu. Prof Pak?
Ya.
We appoint you as the co-host also, so you can remote your paper.
Okay. I will share it, and yeah, I will. Now I can move the files. Okay. So hello everyone again. I'm sure you are quite busy, and everyone is having difficult times since we are all having new environment. Now today is the second day, and since I saw the poster yesterday, maybe the audiences are expecting the person with intellectual property information. So I brought cases that Indonesian citizens are familiar with. I wrote the book with the students, double degree student in UII and Yongsan University. They are all now the lawyers, and these cases, I think you might be interested, so we can discuss it together. Okay. First case is Indonesia-Japan cooperation, and this is called the Shiseido, the cosmetic company Shiseido company, Shiseido case in 2002. And second case I'm going to deliver is Toyota Motor Corporation and Neotedi Siswanto 2010 in Indonesia case also. And next case is a DC Comics and PT Marxing Palm Moore in Indonesia 2021. Just delivered this case. And this is also about the well-known trademark and popular comic book case, intellectual property case. And another one is Hugo Boss, the wearing outfit company, and having similarity in famous marks. So I will also like to discuss about this outfit trademark. And another case is IKEA or IKEA. I usually use the term IKEA in US, but in Korea, everyone say IKEA. I don't know what's proper for Indonesia.
IKEA is the correct answer.
IKEA.
Yeah, no, IKEA.
IKEA. Okay.
Yes.
So in
Indonesia, we usually
California,
call it IKEA.
yeah, in California, everybody used it IKEA, but in Indonesia and Korea use IKEA. So we use IKEA. Okay, and another one is jewelry case. This is a folklore and traditional Bali product. So I like to talk about the traditional expression culture. Something like a bracelet, you are making it in Indonesia is really good. And I have so many from the Jogja and also the Semarang, and they're all places are good at making traditional bracelets and others. So this is also good discussion that you guys can bring with me. And last one is a selfie case. This case made Indonesia very popular in terms of taking a photo. Since the monkey took a photo, and this became the sensational sensational photography of the or international society. Later on, it became the dispute 2018. So now I begin with the case. Let me go down. Basically, this book had 30 cases, and it all about Indonesia. Okay, so intellectual property right. At any time, if you have a question, I like you to point out what is the concern of yours and question you might have. Okay, and I brought a question of Shiseido case. This one I wrote it, and I thought the key principle of this case is fair and an equitable use of biological diversity, as well as access and benefit sharing are set rule for traditional knowledge. I hope you do agree, right? Because Indonesia is so full of traditional knowledge and biological diversity. Once I had a professor from Malang, and she had so many patents over the product of medicine, and the medicine came from the Malang plant, and that plants are used to make animals better in their lives. So she had so many patents from the products in Malang. That's how it is in Indonesia, having a biological diversity. And this is one of the case. And Shiseido, I'm sure all the Korean cosmetic companies notice that Indonesia is the country we have to go to find the good source of cosmetic ingredient. So Shiseido, one of the company that is very good at making the cosmetic products, it's a multilateral cosmetic company, of course, and this one started as a first private Western style pharmacy in Ginza, Tokyo, in 1872. This you might not have noticed before. So this Shiseido company was a pharmacy before in 1872, changed the product of selling to cosmetics because it's a kind of similar chemical ingredient they are using it. So in 1999, Shiseido Corporation applied for the patent containing Indonesian traditional herbal substances. This, I think you can pronounce it better. Long pepper in bahasa Kup Java and orang aring, orang aring, and jakang. And also it said Pilatus Niru. I only familiar with the English version. Mereka Bolong and Tamu Cookie and Zurumbet and Jamu. This I'm very familiar with, Jamu. And these are the ingredients that the Shiseido company had tried to register the patent with the product in cosmetics. Okay, so what they have done is in 1999, Shiseido company filed the patent in Japan, not in Indonesia, in Japan. So they had a serial number. So you know how this patent moves. When you have experimental product and you think you can get a patent, then you apply for registration, right? So once you have registered the product with the open information, they give you the registration number. This is not the patent number, but registration number. So it means that patent is pending. That is also means that patent has not been given yet. Sometimes we use it permitted patent, but this is a number for registration. So they got the number, serial numbers, blah, blah, blah here. And then NGOs in Indonesia had noticed that this is serious, and they confronted Shiseido by having a massive boycott. And what happened in 1999 made, this is not the court decision, but Shiseido Corporation withdrew the patent application containing Indonesian herb in March 2002. This is a big success of the Indonesian NGOs, making one of the big cosmetic companies to drop the application due to the improper ingredient information contained in the patent application. What is concerned for this case is there are several points that I like to point. Is what is culture and traditional knowledge that is protected in the patent? Patent protects. May I ask question? Does patent protect idea? No, patent does not protect idea. Idea, we all have it. So idea, everybody can have it. You have to make something out of your idea. So patent itself does not protect idea per se. Once you make a product out of the idea, then they have a novel, that means the new idea, invention, then that plus it is applied to the industrial purpose, that will give you the patent. So now going back to the point of culture and traditional knowledge, 2003 Convention for Safeguarding the Intangible Cultural Heritage stipulated the here the definition of intangible cultural heritage. What is intangible cultural heritage? I'm sure Indonesian students and also the citizens are very familiar and used to surrounded by traditional heritage. Every time I go Indonesia, there are so many professors giving me the batik, which I cannot really wear because the traditional batik has a little bit stiffness. So when I move, I cannot just move well. But it's very lucky that Indonesian citizens are well adjusted to the batik formation. But the drawings, once I went to the Jogja market, there was a artist drawing the batik patterns. Wow, that was a really amazing. So that drawing itself is intangible cultural heritage. Here is that expression, knowledge, skill, and also instrument, objective, artifacts, and cultural space associated therein. They're all cultural traditional knowledge. So I said, idea does not protect it, right? And then I also said culture and traditional knowledge protect it. How it two goes together? Maybe someone thought, oh, this drawing will be a product of the market, and this is a beautiful, so people will buy it. So this came from the idea, and the person put it into the product and made it and sold it somewhere. But for it to be protected, you should not reveal it to the market until the patent is given to you. So that's why the idea itself is not protected, and culture heritage is protected despite of the reveal of the product in the market before getting the patent. So it's a two thing. Culture, traditional knowledge itself, it cannot be protected through the patent because usually it's coming from grandma, grandfather, to mother, father, to son and daughter, and grandson and granddaughter. It coming down generations, right? So it is a reveal through the family members. It cannot be applied as a patent. So that's why we are protecting it in separate legal frame called cultural heritage, right? Okay, going down here. Okay. Let me move it here. Okay. So the convention provided positive list of domains. This is something that intangible cultural heritage convention think important, and this is a positive list. Let me explain that there are two ways of making treaty, as you might have known very well. Those treaties trying to protect something, they are two ways of protecting the matter of their concern. Making a positive list, or second is making a negative list. Positive list means that they only protect the things listed positively. Second way is negative way. So negative way is you do list negative object that will not be protected, or you should not use, or this is a prohibited product. Something like a chemical convention usually use the negative list way. But here they use positive list. Here it says oral tradition and expression, including language as a vehicle of intangible cultural heritage, and performing arts, social practice, rituals, and festive events, knowledge and practice concerning nature and universe, and traditional craftsmanship. So if you use positive list, that means that your protection list is a bit narrow, right? But you are surely protecting these lists. But then again, your domestic code can help to expand of the definition of these languages. Then it itself can expand a little bit, and in total scope of the protection grows as well according to the trend and new generation. Okay, so this is how it works. Okay, and second convention concern is Convention on the Protection of a Diversity and Cultural Expression. Cultural Diversity Convention, which is called, and it also protects cultural diversity, right? Without protecting cultural diversity, simple example can be potato. In Korea, if you go market, you only see two kinds of potato. One is big and one is small. But when I went to the Mexico, there are more than 20 colors of potatoes in Mexico. How is it possible that they enjoy so much of the diversity even in potato? In Korea, we only have two kinds of potato, big or small, right? So this diversity convention trying to protect the products of all kinds that make us enjoy more fruitful and prosperity coming from diversity. Okay, so Shiseido ingredient is also protected by two conventions, and mostly here I like to point out here the access and benefit sharing. I'm sure you are familiar with access and benefit sharing. Okay. Are you familiar with the access and benefit sharing of the diversity, biological diversity?
Not really.
Not really.
Yeah.
I see. I see. How come? I wonder, because Indonesia is full of ingredients, as I can imagine. Something like bioprospecting contract requirements such as prior informed consent and compensations are set at Convention on Diversity, Biological Diversity. This is known as a CBD. I hope you try to search it. You are very good at Googling, right? So you can search for the CBD, which is Convention on Biological Diversity, as well as Nagoya Protocol. Nagoya Protocol made all the countries to share the benefit from the having using the genes here. Since you said you are not familiar with the diversity method, access and benefit sharing, let me just directly go to the Indonesian law here. Indonesian law is that Indonesia accepted International Treaty Nagoya Protocol by law number 11-2013 on ratification of the Nagoya Protocol on access to genetic resources and fair and equitable sharing of benefit arising from their utilization to the Convention of Biological Diversity. This means that any country want to research on anything using Indonesian plant or animals because they are having genes inside of a plant and also the animals, and this is the part of this law. So they have to equally share the benefit. So this is the law in 2013 from Indonesia. And also draft law of management of a generic resource was introduced in 2005, 2009, and the term of 2010 to 2014, again 2015, 2009 parliament session, but not passed the plenary session. So this means that the law has not passed it, right? And revision of law number 5-1990 on the conservation of biological resources and their ecosystem is currently also a bill. Means that this is still a bill. It's not passed and this is not enforceable, right? So if you cannot enforce law, that means that you cannot gain benefit of having this law. Okay, so this is still a bill. In 2009, when I was writing this book, it had a new title called The Preservation and Utilization of a Genetic Resource. This is a title. And since Indonesia covers diversity through law number 5/1990 on conservation of living resources and ecosystem, law supports ABS. This is a benefit sharing. Benefit sharing system should speed up the process. Passage of the amended law will make possible, and here is that implementation of knowledge and technology science gave hardship to foreign researchers. Why do you think foreign researchers are feeling hard when this law passes in Indonesia? Can you guess? That is because once Indonesia has a stronger law, foreign researchers cannot take any of the genes in Indonesia without paying anything. This means that they have to pay it once this law passes. Then what do you have to do? Make this law pass. So foreign researchers can pay the money when they use the genes in Indonesia. This is the same case in in Korea. You know, you are familiar with the Christmas tree, right?
Yeah.
Yeah, Christmas tree. You know, this the original gene of the Christmas tree is from Korea.
No.
No, we didn't know, right? I even didn't know. This is a particular gene only existing in Ulung Island. This is a kind of island between Korea and Japan. And there's a dispute island next to Ulung Island, which is called the Dokdo Island. And in Ulung Island, there was like a very small tree, green, despite of the very severe weather. So the foreign, which is actually the American, took this gene, this plant, and take it from the Ulung Island, take it to America and researched it, made a new and big Christmas tree. But originally from Korea, they didn't pay anything for taking this tree. Now, is it fair or not? Yeah, sometimes we say we didn't know. So those people who know have a right to research, so they can take it whatever they want. But now, since Nagoya Protocol has passed this since 2018, taking genes from another country for the purpose of research itself is not allowed. When is it allowed and when is fair? When you pay it. Research has to pay it. And when they make a product out of the generic resources, then they have to also share it. Usually 10% of what they are selling. Imagine that Indonesian government can get 10% out of the income, out of the money that Shiseido is making when they made the product from Indonesian generic resources. It's a very good source of government funding, right? So this is fair. And if you don't get paid, this is not fair from now on. Okay. And also trademark and geographic indication is also things that relating to this Shiseido. Geographic indication, the students from Hukum will be familiar too. Also, trademark, you all know, right? Is there anything you are wearing, having a popular trademarks? Something like Nike or the Hugo Boss, or something you are also using, maybe Fila, which is also, there is a Fila Indonesia also, right? A Polo Indonesia, right? Polo, those things are popular trademarks in Indonesia, right? Also, the Indomie yesterday I mentioned is a trademark. They're selling ramyuns and others, right? Geographic indication is something that only certain geographic region has it. This term has developed in France. 1935, French government regulated geographic indication, which has 4 levels. This is for wine, right? So they made a special kind of geographic indication to make wine expensive. Once you have intellectual property in the product price goes up because of the price we have to pay for the trademark, geographic indication, patent, and copyright, right? Before, we used the music without paying anything. And we thought the musicians like to play for us because they want to be famous when we hear a lot. But nowadays, it's the opposite. Whenever we hear music, we have to pay. It is protected through the copyright. And also for this purpose, for this education purpose, among the whole book, something like this, if someone like to use my book, then only 30% of the whole book is possible to use for the purpose of education. If you use it more than 30% of the one book, it is infringement of copyright, but sometimes ignore it, right? But here, that's a rule that having 30% using is a maximum for the whole book. So the GI here, I like to share the history of a GI, and there are two countries they are interested in having the GI, geographic indication. Which country do you think is very interested in having this cultural diversity protected? Of course, it is Europe. Europe has the most old places, and US has a short history. That's why the government in the EU tried to protect cultural diversity and also geographic indications and intellectual property in old method. But US kind of invented intellectual property in a modern way. They invented to protect Mickey Mouse. They invented intellectual property lawyer to be rich. This is an invention by the US because they sold everything. I mean, they sold so many products, but then again, they thought, we need something else. We are selling so many products already to the world, but this is not generating so much of the revenue we want. So that's why US had a discussion in the governmental stage, and maybe we should protect the copyright. We need something like a new service protection, which is finance protection. This is a protect through the trade secret and also the company secret. That's also the trade secret. They are not telling. Do you know what's the ingredient of Coca-Cola? They are not revealing it. So Coca-Cola does not have a patent. Once you have a patent, you have to reveal what's inside of Coca-Cola. But you get confused. Oh, isn't that patent make you rich? And Coca-Cola, if they have a patent, they will be richer. Why don't they apply for the patent? That is because they don't want to reveal the ingredient inside. They don't want anybody to know what's inside. That's why Coca-Cola and Pepsi has a different taste, right? Pepsi could not figure out what's inside of Coca-Cola, so they could not make the same taste as Coca-Cola. They made a different products, right? So it's a strategy Coca-Cola adopted. We decided not to disclose it. This is much better than disclosing it because the patent will disappear after 20 years. But Coca-Cola has been selling and will be selling more than 100 years. Not having patent is much better. But copyright is protected 70 years after the person dies. So it's much worse having a copyright. Anybody writing a good poem, please have it protected through the copyright. So these are the inventions the US made because there are so many artists in the US. Also, there are so many people, so many artists in Europe, but having modern artists, US is a little bit trendy, and they have Disney. So that's why the US had made the copyright protection stronger, and EU had the opposite position, but end up having agree on that. So here, let me read it to you. Having a different system for protection of a geographic indication, the U.S. opposed the idea of having geographic indication. So what happened in the WTO intellectual property format is that finally EC had to settle with the 3 articles in the TRIPS. So EU wanted to have more articles clearly written in TRIPS, but they couldn't because the US was in objection of it. So for Article 22, the protection of a geographic indication, here the Article 23 for additional protection for the geographic indication for wine and spirits, and 24 for international negotiation expectation. So that's the 3 articles that the EU had received with the fight over the US. So this is how the geographic indication has sorted. In Korea, are you familiar with the tteokbokki?
Yeah, I like it so much.
Thank you. Thank you. So if you are familiar with the tteokbokki, there's a place called the Shindang-dong, which is very popular for the very spicy tteokbokki. And they like to have a geographic indication given to them. Once a geographic indication certification is given to the place, the price can be higher, and also they can get more protection over geographic indication. So this is how the market is working. And I hope if Indonesian government is thinking about protecting more of the traditional batik, and as I saw it, the batik in Malaysia and batik in Indonesia is totally different, and their drawing and the outfit are so different, and Indonesia has their own sui generis system, and I think you can have a geographic indication certified to the products of small villages in Indonesia, right? Because you have so diverse traditional products in small villages I have visited. There are so many beautiful products, and those are not protected because only the person who sells it want a small amount of money, not the big money. But foreigners kind of notice these are very valuable. But the Indonesian government does not protect it. Then the people having good artistic figure inside, they're losing their chances to become bigger. So government has to protect and give them the protection through the geographic indication. This Shiseido case is one of the cases that the Indonesian NGO had made a big indication to the society, international society, that Indonesian citizens care about our genetic products. So this is the case. And I'm so proud of Shiseido case. And I usually mention Shiseido case to Korean students too. This is really important for protection of geographic indication and genetic resources. Okay, so here, I'm sure you know the Toyota car, right? So Toyota Motors Corporation is another Japanese company making car. And here, Toyota Motor Corporation is a Japanese multilateral automotive manufacturer, and they use the Lexus and L logo, right? And usually you can see the Lexus in the car, right? And they had a trademark here, renewal in 2002 under the number here for class 12, go up, 12 vehicle with the purpose of protecting cars, auto parts, accessory, etc. in Indonesia for distinguishing the result from other parties. So this is the Toyota had a patent in Indonesia. And 2010, the person name called the Neo Teddy Siswando in Indonesian businessman submitted the trademark registration to Lexus brand. But this is not the car. They used it in paint. So do you think using Lexus logo in my outfit will give a little bit of attention to the consumers? Maybe the painters kind of thought that having a Lexus logo in that product will give a benefit to the person, right? So he used it in class 2. He used it in a class 2. So the lawsuit aimed to declare the plaintiff is exclusive right holder of a Lexus trademark number in Indonesia, state that a dependent trademark in words and sounds are the same in principle as a plaintiff's trademark. So that court said, using it in the car and using it in the paint is a little bit different, but Lexus is also popular in Indonesia. Kind of everyone knows the Lexus logo in Indonesia. So if somebody use it in other products other than car, still consumers get confused. So this confusion is the biggest part of the decision crisis. Here, criteria says exclusive right of Lexus and logo L trademark stating the dependent trademark in words and voice is the same. So the court canceled the dependent number trademark registration with all legal consequences. So this is a trademark case in Indonesia using the similar. So what kind of a test the court has used is similarity test. If the logo is a similar, but nowadays, I'm sure, I think you are familiar with the mega bus. Are you? Mega bus?
Mega bus is what kind of bus is that?
Yeah. It's a mega bus. It's not a real world. It's an internet world. Inside of it, you log in, and there is an office. So in Korea, there is a mega bus. The office is the companies are using mega bus, so they don't go office. They go office through the internet, and they have to turn the video and audio from 9 to 6, which is the office time. And after they just out of internet, and that is going home. But actually they are staying at home all the time. So that's why the Gangnam in Seoul, there are so many empty offices. They don't need to go office. They go office by internet, cyber world. Cyber world is called megabus. Yeah, it's a new thing, and it will come in 5 years. but already people are using mega bus. Since Korean universities are not allowed to have ceremony for new semester, some of the university use the mega bus to greet the newcomers. They all entered in cyber world. They met in a cyber world saying hello, say hello to the professor, and they went home, but they didn't change any places. They were all the time stayed at home. That's why the people are buying houses outside of Seoul instead of Seoul. But there are demands in Seoul, but still people who tend to like stay in a nature, they don't have to go. Even the people who stay in Jeju Island work in a Gangnam office through the megabus. They don't have to go. They maybe have to go twice a week or maybe one time a week. It's a thing that they don't. Maybe in Jakarta. Jakarta is a very busy city and everybody is having a traffic jam. When I went from Jakarta to Bandung, it took 7 hours because of the traffic. You know, that in that case, you can just stay in Bandung and you don't have to go Jakarta office using the mega city. So here, similarity tests and well-known marks are now popular in term in court that everybody get confused if you use the similar logo to it, right? Next case I like to mention is also the similar ones here. DC Comic. Anybody familiar with the DC Comic case? Superman.
Not really, but I like to watch their movie though.
DC Comic
I'm older,
is
so I get it. Some.
Yeah, you get it, right? Yeah. So this is a Superman iconic character, and here it said that DC Comic sold the comic books in Indonesia for a long time, but was not patented. And then there was a businessman in Indonesia made use the DC Comics Superman logo in PT Marxing Pam Markmore. So what happened is that DC Comic didn't notice it until this here the Superman. Let me see. The Superman is one of the iconic hero character of DC Comics with a famous icon of a blue uniform, red cape, and S shield on his chest. And then here, dependent PT Marxing Farm, Surabaya-based food and beverage company used the waffle product, chocolate waffle, make a Superman. It is possible, right? It is possible. What you can assume is that when you eat this waffle, you become stronger like a Superman. I'm 100% agree on the idea of using Superman for selling waffle in a supermarket. But DC Comics said because Indonesia has so many populations, so big country, one supermarket use it, everyone will use the Superman logo after all. So we have to block him from using it at the first time. Otherwise, everyone will use it. Indonesia has fourth largest population in the world. So we have to stop it now. That was the intention of a DC logo. And they they actually lost this case. DC Comic lost it because the attorney has used the wrong power of attorney paper, and they didn't mention properly. But at the end of the 2021, finally, even the DC Comic has to pay the fee, 5 million rupees at the time. That means that they lost case. Later on, the court reversed the decision, made the supermarket cannot sell the Superman waffle after all. So this is a claim for famous, let me go down, famous trademark here. So it's a well-known trademark criteria was also used by the court. Okay, so when I know since it is era of connecting all the world through the internet, what is famous trademark is depending on maybe cyber world. So maybe something famous in Indonesia, you can make it famous because Indonesia has large population. You can make it yourself in Indonesia and just introduce to the world. They will instantly will be popular since Indonesia has already have a big population, right? So one WhatsApp message and then another message, Indonesia has a great resource that can make company well. This is a part of also the polo, the t-shirts. The US, the polo company could not invade the power and the right of the Indonesian polo, because Indonesia polo was there before the polo logo t-shirts became popular. So Indonesia logo is guaranteed and respected. That was the first one, right? Okay, so this is a Superman one. And let's go to the Hugo Boss. It's a similar one. Maybe I should go, instead of going Hugo Boss case, let me go to the selfie case. And then we can discuss about the traditional ones. Yep, this is the monkey made the Indonesia popular. Okay, so in 2011, British photographer David J. Slater traveled to National Park in northern Sulawesi, Indonesia. You all know Sulawesi, right? And David Slater took a picture of a local wild in the national park, and he claimed he was especially looking for a very close shot of monkey's face using a wide angle lens of one of monkey named Naruto. You can Google him. He's so popular. Her name like the sounded name of the same character from the Japan manga series, which is a comic book. And Naruto, she took a photo herself. And this photographer just left the camera, something like this is my phone, and just left it here. And then, oh, monkey came and just pressed the button and took the picture of herself. And this is a picture that monkey has taken it herself. And how this became popular is that before, the monkey picture was not really something that showing the happiness or the teeth. And the monkey picture was without teeth and just, maybe the picture was not really reflecting the emotion of the monkey. But this picture, can you see that she is happy?
Yeah, because
Yeah.
she's smiling.
Yeah. So this is the first time the monkey shows emotion through the picture. That's why this picture became so popular and became the source of dispute. And it actually was named by a local guardian officer, and her name Naruto, and she took the picture. And what happened was that David took a picture of it and he made the book and he sold it. Right here, Naruto snapped several photos of himself, no, it's herself, with a camera that belonged to photographer. And this picture of a monkey selfie picture was first published by Daily Mail, and the feature story and that went viral. So it became so popular. The picture was used in the Wikipedia website. Even you can check the Wikipedia for this Naruto case, right? And 2011, several publications indicating Daily Mail, Telegraph, and Guardian published the story. And Monkey still camera and snap himself. Keep saying it's himself, but it was a female actually. Okay, that was a title, so I could not change it. A camera on the tripod triggered by the monkey, and the camera started by monkey. And these are the ones. And then quote decision was 2015. People for the ethical treatment of animal in Indonesia, PETA, filed a lawsuit against David as a publisher in the California, claiming the monkey should be copyright holder and PETA should be appointed to administer proceeds from photo for the benefit of the monkey, right? And what happened was that in the U.S. Court of Appeal for the Ninth Circuit dismissed the copyright. So at the point was it? What was that the issue? Here, jurisdiction. This is the concern later on. Let's go to the ownership. Let's go to the ownership. Yeah, I didn't draw it. Okay. Okay. Let's go. Oh, I didn't meant it. Okay, select to move it. Oh, up. Okay. Okay. Here it says, not this one. Just move it a little bit. Okay. Here it says in April 2018, the appeal court confirmed the animals do not have a legal ground of copyright. Indonesian copyright does not recognize animal owning the copyright. Although monkey selfie was taken in Indonesia territory, monkey cannot own the copyright under Indonesian law. Picture taken through the photographic work can be an object of Indonesian copyright if Indonesian means the people have taken the picture. Article 1 versus 2 of the Indonesia copyright number 28 of 2014 says creator is a person or group who individually or jointly produce a unique and person creation. So since Indonesian copyright does not protect the product out of animal taken by the animal, Naruto could not get it, could not get the ownership of the copyright. So this is the one, but there was a happy ending. Let me show you. David, the person who owner of the camera, donated 25% of future revenue derived from the using and selling of the monkey selfie to wildlife organization that protects the created marku habitat in Indonesia. So 25% of benefit went to the Indonesia citizen residents, right? So this is a part of discussion I like to go on, that we have to share the technology, but we also have to share the benefit of it. And this is a nice way of sharing of the technology and also the benefit, right? So for now, since we have 30 minutes left, I'd like to contact the moderator. Is there moderator? Can you take could you take the questions first? And if I have more time, I will discuss more of the Indonesian copyright and or the intellectual property.
We have some questions, as you can see in our Zoom chat. The first one is from Agustin Puspas. She's a student. She looks like a student. She asked about the traditional culture, about the kuda lumping, wayang, and some traditional games. And as we all know, protection of traditional culture and knowledge has been concerned in Indonesia, same like in Korea. And we actually have so much traditional culture. And it shows that our IT model for traditional culture protection doesn't work. She said it looks like doesn't work. So what legal model should be adopted for its protection and suitable for us, like China? They already preserve their traditional culture with IT. That's the first question.
Okay. So what they have done is making online database. After every country are now equipped with the online database, every country database, all the countries are connected. So once you can use it, but you cannot patent it. So that is a regulation as far as it goes. Online protection, that's I think it's online registration. Registration is now open to all countries with the patent system. So this patent system is connected all around, and patent officers has to check the database before they give a patent. Otherwise, in small countries, they will have a patent in their country, and that businessman will gain money over this patent, which is not proper, right? So online system is open, but those cities not having online system should ask government to access to the online system global. There is a global patent. I also have 2 patents in Korea, and they recommended to have an international patent, but because it took so much of the money, I didn't had my patent to be internationalized, but there is an international patent system that allow people to check. So that is called patent. Let me patent cooperation treaty. So it's called, I just typed it, checked it, patent cooperation treaty. It came from 1970, and anybody, any country can join. If a cooperation treaty is on in Indonesia, Indonesia can protect online information.
Okay, Prof. So let's move to second question. It's from Jana Badra lecture, Mr. Winalna. He said that he asking about that few years ago there was an issue about research that happened to Indonesian blood. Ministry of Health gave Indonesian blood sample to us. Just look up online about it one already to the fact that there is a Christmas tree gene issue. I was wondering, is there any regulation that public can see a progress those research?
So Indonesian blood sample, what is blood sample of Indonesian? To us.
Miss Nara, can I speak?
Yeah.
Okay, so like few years ago, there's a big news that the Ministry of Health Indonesia give Indonesian samples to US. I look up online, but it's gone already. I don't know why. And I'm just wondering that you mentioned about the Christmas tree gene issue. I'm just wondering, is there any like what happened to the blood? I mean, then several years after that, pandemic come along, and my brain just bursting around. You know, like, is that a conspiracy or I'm just asking about the regulation, about the risks that involving a big country and many peoples, and I think as a humans is our right to know the progress of the research. And what I'm asking is there any regulation that we are a public can see the progress of those researches that involving public matters? I mean, yeah. Thank you, Professor.
Yeah, sure. It's yeah, I thought it's us, it's a US. Yeah, then I understand. Okay, so the Minister of Health gave Indonesian blood sample. That means that in different island citizens have a different type of blood. Of course, everybody has a different blood, but they have A, B, O samples, right? And they gave a US, and now you want to know whether the blood has been used in US, where, and whether you can get information about the research conducted using these blood, right? Yeah.
Yes.
Depends. Also, this kind of research has been conducted in Korea too. Even in Korea, in the port, seaport, they said the U.S. military is importing strange virus and are researching it at the source of in Korea, a territory of Korea, and somehow that the virus can spread out. That's why people sometimes suddenly get sick, or those rumors are always or surrounded here.
Yes.
So the information how this the health ministry giving blood sample to US become a news, I'm not sure, but there are several cases has the blood samples are swapped the blood samples were swapped for the research purposes. And when they use research purpose, usually the import and export regulation state it is secret. So, for example, you give immunity to the diplomats. You cannot touch their bags or their books or whatever they're holding it. So these research purpose packages are not allowed to investigate during the importing exporting process. So that must be secret in purpose. I'm also surprised that this one thing, the news got leaked. There must be brave newspaper person who leaked this news. Secondly, you also remember this news and wondering the after or what happened. So I'll also follow up. We can talk later about this kind of incidences because we also talk about the Wuhan virus has been leaked, but this was also part of research. So now we can claim the immunity given to the research is not really the immunity we're supposed to give it to them. If the public health became dangerous, maybe their immunity should be lifted and investigation should be done thoroughly. That's the process we should, go, direction we all had to go, I think.
Yep. Okay. So in the moment, there is no regulation that public can access to see the progress. Yeah. So it's more like secret.
Accessing itself is prohibited through the regulation.
Yeah.
I
understood. Yeah, I just wondering that in the Christmas tree they make it a bigger tree.
Yeah.
Can we imagine that it's just sample blood? Is there any winner now in US? We never know, right? I'm just kidding.
Yeah.
This is my head. Just kidding. Yeah. Thank you, Professor. Thank you so much.
Yeah. In a Amazon desert, they have a gene bunker. So
we can put our genes to there.
No, in US, they're collecting all the genes from
around the world.
Around the world, and they put in a bunker. Whatever happens, the bunker is a safe. So also, something like we don't have a dinosaurs anymore, but they have it. They have a small samples in the bunker. They can make it later alive. Something like all the genes we don't have, they have it. Maybe the genes distincted in Korea, they have it in Amazon bunker. It's a very known factor that US and UK has a bunker that saves genes for all the countries.
Okay, thank you so much.
Yeah.
Maybe the next question. Thank you.
Thank you, Prof. Mark, for your answer. Anybody has another question? The question in the chat. Anybody has any questions?
Tita, are you moderating outside in Korea?
Yeah.
On the road?
No, not on the road.
Looks good.
The background, you mean?
Looks good. It's green outside.
That is in Gangnam, actually. Last week I went to Gangnam.
I see. Okay. So if there's no question, I'm just going to go through the cases that I mentioned.
It looks like we have one more question.
Okay.
No.
Oh, yeah.
Mr. Winarno, he said that he is a student.
Yeah, very brilliant, excellent student.
Okay, very clearly. So
Yeah.
just go back to your thesis.
Okay, I'll just resume the case. Okay. Dita, your voice is not clear from here, so I will resume my contents here. Okay. Okay. So the last case I like to mention is a hardy drawer. And this is a Bali motif folklore dispute. And key principle I like to point out is craft design representing folklore that is in public domain can be used even by foreigner. You know, this is a very sad story for Indonesia. This is a very sad because the traditional Bali folklore is very beautiful, and government had plenty of time protecting these motifs, but this another businessman took the design. He became richer than the traditional craftsmen in Indonesia. Let me read you the facts here. Ketu Deni Ariasa is a traditional Bali silver craftsman. You know how beautiful it is in Indonesia making the silver crafts. It is impossible for us in Korean to make that kind of craftsman work. It is just simply impossible because it's too narrow and you make it very detailed product, right? And then Ketu Deni has exported traditional Bali silver handicraft products. So that means that he took it to the country. In 2008, this Deni was accused of infringing copyright by plagiarizing the work of silver jewelry of a U.S. Canada entrepreneur. Deni used the floor and crocodile that are traditional Bali tribal motif and found in almost all art ornaments in Bali culture. But Bali people have been using this motif freely as a form of a Bali culture expression. That means that everyone in Bali can use it without getting any permission, right? And this John Hardy, a Canadian designer and artist, found the John Hardy jewelry, founded it, and was inspired by the Bali jewelry, and he learned the technique from the local Bali artist, and then established his business in Bali, 1975. The main business focused on handicraft jewelry, and this Indonesian company, which is a manufacturer of a John Hardy product, which means that this John Hardy made another company, asked them to make craftsman jewelry, and then imported back to Canada and sold it. That's why he can buy it in a cheaper price and sell it expensive, right? In 2008, this Karaya Tanggandi Inda registered the copyright of a motif DJKI under the number 030376, including the description of creator of motif, right? And this French citizen who living in Bali, Indonesia. Then in 2008, Hardy Jory and PT Inda sued Deni for plagiarism and copyright infringement. So it is fight over foreigner versus foreigner. and in between there was Indonesian artist. It's so interesting. Indonesian artists is not the best, and they sell it very cheap, and all the benefit of it, the Canadian businessman got it. He became richer. At the district court level, Danny was not proven guilty of copyright infringement because the judge did not find any similar aspect of the craftsman, right? And then judge was influenced by the witness experts in the court saying that the work difference basic idea is not possible to make the same result. So all influenced by the substantial element of the product. That means everybody has looking at the similar design of it. So we cannot make the similar design to be protected because it's just traditional, right? So that's why this case became a sad story. So the person who sued lost it. That means that nobody can get the protection over Bali folklore. Here, I mentioned about the protection of a traditional expression culture in Indonesia. Let me go up. And expression of a traditional culture, especially the traditional motif of a silver Bali, is protected by the copyright. So maybe the government can push this not through the not through the cultural product, through the copyright. Since it is a design, it should be possible to make it through the copyright, but it failed. So that's why any of the traditional design cannot be protected in Indonesia. For example, a fluid motif that is an expression of traditional Balinese culture now owned by foreign citizens. Right. So this is the kind of sad story, but yeah, that's why the law has to be a little bit strengthened. In 2014, law number 28, copyright strengthened the protection of a traditional expression culture. Yes. And new copyright law protect folklore owned by the state without any expiration date. Yes. Now you can protect the folklore using the law number 2014. For the use of traditional cultural expression here, one must pay attention to the value of the lives in the developing society, and the goal of protection is the compliance of the traditional cultural expression as long as the completion is original work. So we should respect the original work of our ancestor, either in Korea, also both in Korea and Indonesia. And to show the respect, law has to be strong. Yes. So this is my final dialogue and speech for today's intellectual property. Remember, Indonesia has a lot of bills that has not passed yet to protect generic resources. I hope you push more of the parliament to pass the law to protect plants, animals, any of the generic resources in Indonesia. So foreign research has to pay for what they're getting and share the benefit of what they're selling. Make them pay. Thank you.
Thank you, Prof.
감사합니다.
감사합니다.
감사합니다, Desonim. Thank you, Prof.
You
We'd
too.
like to ask for IP today.
Okay. So,
Miss
Kamsahamnida.
Dita, can I ask Prof. Park?
Ibu, ya silakan Bu Dia.
Okay.
yeah,
It's
stay
about
here.
the folklore in Korea. Yeah.
I see.
Professor Park, can I ask you about the folklore in Korea? What about the regulation of folklore in Korea so far? It is the regulation in Indonesia is part of intellectual property in this regulation. If you see in Indonesia that there are so many Indonesia cultures that cause international dispute. It seems that culture in Indonesia is not sufficiently regulated in the copyright law. But the Ministry of Culture has a database of that culture as national culture heritage that will be registered with the World Heritage Center under UNESCO.
Right.
And how about in the Korea? What about the regulation in Korea about the culture? I think is a part of the intellectual property right or no? Maybe you can explore the answer with me. Thank you, Professor Park.
Yeah, we do protect it through the geographic indication and also the certification system. So I gave an example of tteokbokki. Even tteokbokki, which was the is the product in Joseon Dynasty, is still protected, and this is part of EU FTA. And they gave us the list of protected geographic indication. In response to EU FTA, Korea decided to list all the important the local tradition that were listed in the geographic indication. Now they are protected through the geographic indication. Basically, it is also protected through the UNESCO registration as well. But there are two separate systems. Some products are not fit to the standard of UNESCO. Then geographic indication, they apply. So they get protection over it.
Okay.
Yeah.
Okay. Thank you, Prof.
Thank you. Thank you.
Thank you, Prof.
Yeah.
I think that is all of the questions, and we should continue on tomorrow, still in the same time.
Yeah, tomorrow, right?
Yeah, tomorrow we still have the third session, right, for the public lecture.
Yeah. So thank you for having me. I really appreciate your presence. I enjoy it. Thank you. Thank you very much.
Prof, and
Thank
you
you.
for your participation.
Kamsahamnida. Thank you. Terima kasih.
Terima kasih semuanya,
Thank you,
Bapak Ibu.
Prof.
Undangan.
Terima kasih.
Terima kasih.